This actually is a good point for us to begin a discussion because one of the questions we thought we would explore is what are the seats and institutions that parties to Belt and Road Initiative projects or disputes would consider, and I do wonder how much it correlates to the developmental chart that you've got there. I imagine there might be different commercial considerations at play. And what kinds of factors do clients look at in terms of deciding for a seat? And another question I'd like to pose is, if you look outside Hong Kong and Singapore, what are the realistic options? To what extent is China a realistic seat? I mean, that's what China is trying to push for, but to what extent has this reality as it exists now match that?
Right. Perhaps I would kick off, if you
Sure.
Well, so I don't have time to illustrate about. Actually, I list about 12 factors, what the parties they will consider when they are choosing an arbitral seat, quite a number of which have been listed in the table. Rule of law, judicial support. We find it quite interesting. Justice Reyes and I, we find it more important in the judicial support than the rule of law. Say, for example, in China, for those of you who are familiar with China, China doesn't have judicial independence, right? We don't exercise separation of powers. But it doesn't matter because China has very good judicial support towards arbitration. Perhaps, Melody can explain out there. There's a pre-reporting system where the enforcement, the recognition and enforcement of foreign arbitral award has to be centralized to the SPC in Beijing. Well, if we like to deny and turn down, you have to report it sort of like pyramidically, level by level, all the way to Beijing. So it's very difficult to turn down a foreign arbitral award in China. Secondly, with respect to Singapore and Hong Kong, if you look at the breakdown of the HKIC cases and SIC cases, you will see that HKIC has about 50% of the cases which are from China-related. Right, thanks.
Maybe I could just quickly chime in. And the thing is, I think in terms of the factors of an arbitration, a lot of clients or arbitration practitioners would very much emphasize on which institution you choose and sort of the venue of the arbitration. But I would say that in my experience, actually the language of the arbitration is probably, in my opinion, more important than the other factors, in the sense that I'll give one example quickly. I just had a CTAC arbitration. The arbitration language was English. It's a very complex case where we represent basically Japanese and Chinese parties, and the other side is a U.S. company. So eventually, because of it's a complex case, and also the arbitration language being English, so eventually, both the side arbitrators as well as the chief arbitrators, they were one of them is from France and two of them are from Hong Kong. So essentially, within CTAC, which is not famous for handling international style arbitration cases, they have conducted arbitration cases, I think, very similarly to what you would have in Hong Kong at HKIAC. So in that sense, and that case actually is a good example to echo what Professor Gu was saying, that you would be able to get the benefit of seeking court interim measures in China, but at the same time to enjoy the benefit of having a full-blown sort of international arbitration hearings.
Leong?
Yeah. Actually, from my experience, usually when it comes to negotiating the 1 minute to midnight clause, the arbitration clause, the biggest argument party has is neutrality. Because that's always the issue. I don't want to come to your country, you don't want to come to my country. We need a neutral venue to arbitrate. And that's why I think places like Singapore and Hong Kong have done so well, because we are perceived to be neutral venues with good judicial support and rule of law that can support arbitration and have got deep resources to conduct arbitration. And that has been my experience in terms of advising clients on the what is the right venue or right seat to choose for arbitration. But having said that, now that in addition to arbitration, there's also the advent of this international court, and that is then the other advice that we have to give clients. Do you want to go for arbitration or do you want to go to court? And I think we have heard a lot of arguments in the old days why arbitration is superior to court and why do people not like to go to court. But nowadays, the international courts, they have been established, particularly SICC has been established, not so much to compete with arbitration, but really to be more as a complement to offer an extra option to parties who wants to have something other than international arbitration. And one of the things that has been touted by the SICC particularly is that they say that they can avoid party-appointed tribunals, and that's a topic that we have talked about earlier. And in fact, it's a double-edged sword because party-appointed tribunals are considered to be one of the great advantage of international arbitration. And yet, it's come to a stage where I think users are beginning to be cynical about party-appointed tribunal because they felt that tribunals are not independent in that sense because they play to whoever who appoint them. And the international courts provide an alternative where the tribunal or the quorum is actually appointed by the Chief Justice of Singapore. And the other one, of course, are the usuals like a joinder of parties. You can join parties who are not party to the contract, and you have right of appeal. And these are the options that is available to client for international court as well.
Johnny, may I pick up from there? Yeah, talking about international commercial courts, I think that they are there to cater to some of the needs of arbitration users. And I will cite from the Whiten case and Queen Mary research, which is very interesting. The survey shows that cost, with 67%, lack of effective sanctions during the arbitral process, 45%, lack of power in relation to third parties, 39%, and lack of speed are the worst characteristics in arbitration. So the promise of international commercial courts is to cater precisely to those needs. I think that's where they find their niche. However, from the same survey, the most valuable characteristics in arbitration are enforceability of the arbitral award, the avoidance of specific legal systems or national courts, flexibility, and the parties' ability to select arbitrators, none of which are achieved by international commercial courts. So I think it all boils down to this. Do the users still believe in arbitration? Because if they do, they will not go into international commercial courts. So this is the first conclusion I have. There are mostly different mechanisms. They will never be competing against each other. It's just they cater to different needs altogether. And the second thing, I think it's more obvious. It all boils down to the leverage of the parties in the negotiation. Right. Yes. So I think that if, let's say, a Chinese investor is negotiating with a country like, say, Brazil, for example, where I come from, I think there's lots of leverage from both sides to negotiate and find a neutral ground. But if you're talking about Sri Lanka, if you're talking about countries that are undeveloped, Djibouti, for example, then you may not have the same leverage from the recipient of the investment. And therefore, I think the trend is going to be moving these disputes to China, mainland China.
I think enforceability is key. And I think as Leong mentioned earlier, there is a Hague Choice of Court Convention, but I think very few parties have ratified it. Yes. But I mean, to add to the picture, there are bilateral recognition and enforcement arrangements, and depending on the situation and the parties involved, I mean, the considerations in a particular case might be more nuanced. Yes. And the point about third parties, I mean, one side always wants to bring in the third party and the other might not. And in that situation, it might not always be that commercial courts and arbitrations
you
are
had
not viable alternatives to each other.
There's an attempt from the Dubai International Finance Commercial Court to make the award issued by the court be turned into an agreeable arbitral award, so it can be enforced. Based on your convention, but I think it's a little bit exaggerated, that attempt. I don't think that other jurisdictions will accept it, but that's an attempt from the Dubai court.
Well, if I can kick in, apologies. I mean, I think SICC is actually doing very well, partly because, my co-author is sitting on the bench of the SICC. I think SICC is actually taking advantage of both arbitration and international litigation. Well, when you see the Wyden case and Queen Mary survey, you see what is the biggest advantage of arbitration too. The first one is international enforceability, and the second one is confidentiality, if I can say. Cost of arbitration is no longer low today. It's no longer cheap. And judicialization process, sort of like judicialization trend of arbitration is more and more, what we can say it's quite a global phenomenon, whether not only in the common law, but also in the civil law jurisdictions as well. Well, but you will see that in Singapore, firstly, well, it could be confidential, SICC proceedings, according to the party agreement. Secondly, well, when you have an hourly rate for the arbitrators and SICC, the judges, they are kept by daily, sort of, no matter how many hours you're working, or they're kept by a daily sort of rent. And then when William said about, DIFC, they can convert the DIFC judgment into an arbitral award. That is pretty much thanks to Michael Huang from Singapore. You will see that, DIFC, and there are actually quite a number of international commercial courts in the Middle East, they are very, very much influenced by the common law jurisdiction mindset in the Singapore. The DIFC first Chief Justice, Michael Huang, is actually a Queen's Counsel in SC in Singapore, and then they bring all the Singaporean elements into Middle East.
Might I just bring in the China Commercial Court, which we talked about a bit earlier, because one of the, it's got certain structural features that makes me wonder about its purpose, because some of the differences with the Singapore courts, it's Chinese language, Chinese judges, and I think currently only Chinese counsel can appear.
Right.
Although maybe that's not that clear. And you can choose the court, but there has to be a connecting factor still. And that's contrasted with the SICC, where the choice of the court itself is a connecting factor, and there's no need to show any other connection to Singapore. And it seems to me that maybe Professor Gu's research comes in here, because Singapore's commercial court is very much part of a self-conscious effort to attract legal services. And you can see there the idea and the imperative is to be as international as possible. But with the Chinese courts, it seems to me that that's not necessarily what it's trying to achieve, and maybe it has something, going back to the Belt and Road Initiative, again, something to do with controlling and projecting Chinese influence over dispute resolution.
Yeah, I think that certainly there's a lot of truth to that, especially that with this amount of Chinese investment in other parts of the world, and then China wanted to exert some sort of influence over that process. And at the same time, for a lot of high-profile cases, whereas actually one of our clients came to ask me the other day, what about if we submit our case to the CICC, the China the International Commercial Court? Because for foreign party, they were afraid that if you end up being in a local court, the local courts they might tend to protect the local parties, whereas if you elevate it to the level of the International Commercial Court, they might be able to consider this issue in the broader picture, taking into consideration like the political, geopolitical, diplomatic relations of two nations, etc. So that might be something attractive for a foreign party in the right cases as well, I think.
I'd like to just to challenge a little bit.
Yeah.
I think in order for that to happen, the CICC would have to be truly international, would have to have judges, international judges with jurisdictional powers. So now what they have is a foreign experts committee.
Right.
They can mediate cases, they can advise the court, but they cannot decide cases. It's different from the Singapore court, I believe, which has former judges from different jurisdictions. So I think if the CICC wants to be a one-stop shop for dispute resolution in the Belt and Road, which is the original purpose of its creation, to be a one-stop shop, I think it needs to become truly international. So this would be a very important step for the court to exercise its role more properly.
Thanks, Guilherme. I recognize we started a bit after 11:30, and I wonder if we have the indulgence of the organizers to just take one or two questions from the audience.
Thank you very much. Michael Pugh, London South Bank University. Thank you very much for a fascinating talk. I wonder if you could shed some light really on the relationship between the relationship that was mentioned about the Chinese culture of maintaining the relationship, Guangxi, I believe it's called, maintaining the positive relationship, and arbitration. Is it, if there is a disagreement about something and the parties start an arbitration, what effect does that arbitration have on the Guangxi, the ongoing relationship? Is it damaging, or can that be used as part of the mechanism to move towards a resolution and continue that ongoing relationship?
Any
Can I
initial
take that?
reactions? Yeah, sure.
Yeah. Well, I think I know that sort of the in a way, for the sake of lack of better word, I mean, cliches, Chinese people are very Confucius, very much emphasized in the Chinese culture is Confucius. It's all, everything is so harmonious. But that's not my experience, and I think that's not to most people who work and do business in China. That's not sort of how you would describe the Chinese companies, how they approach these sort of issues. And in my opinion, in the sort of the East Asian part of the world, the Chinese companies have become very, very litigious, and that the arbitration has become one of the tools for them to achieve their commercial goals. One thing that we didn't touch upon today, but I think it's worth having a separate topic panel talking about it, is the Chinese company's mentality, in the sense that if especially when you face a state-owned company, in a lot of these investments, actually those are state-owned companies that are invested in those jurisdictions, that part of their corporate governance and also the management of those state officials who are managing, oftentimes they're senior management members of the company. So a lot of them, part of how they are being managed and how they operate the company is that a lot of times their performance would be judged by these sort of proceedings and the outcome of an investment as well. So we had a case where commercially we all thought, I mean, we represent a foreign company against a Chinese company, and we all thought at a certain point of the arbitration, actually, we were able to reach a settlement. And commercially, I think they would have accepted, but actually the settlement failed, the discussion. And the reason is, I mean, later on that actually the CEO of that company told us very clearly that if I accept this settlement proposal, then it becomes my responsibility. I have to explain to my stakeholders why I accepted this deal. But if I go through either litigation or arbitration proceeding, then that's the outcome. So that's not my responsibility. I've gone through the due process, and that's the outcome we have to accept. So in that sense, I mean, you can see that where, I mean, those kind of contentious means can be a tool for Chinese companies to resolve an issue.
Yeah, my experience is definitely the same, and Emily and I, in fact, work on
Yes.
a case involving Chinese and Korean parties, two very Confucian systems, and I can tell you it was not harmonious.
There's a kind of saying that the Japanese and Koreans, they're more Confucius than the Chinese, actually.
I think there was one question. I think we have time for just one more.
Yeah, I have a question. The Brazilian public administration is increasingly using arbitration. However, the regulatory agencies, the state of Sao Paulo, the state of Rio de Janeiro, they issued rules, decrees on different levels of the law, requiring, it was mentioned before, that it's similar in China, Portuguese as the language, see it in Brazil, and Portuguese law applicable. How do Chinese investors look at these requirements?
Well, I represent a few of them. So these requirements, they have some exceptions. So if it's a foreign financing institution, these requirements do not apply. So they can actually circumvent that by lending the money through these organizations, Chinese Exim Bank, Asian Bank. So I think this is a way to go. But it's interesting that, at least from my perspective, attending to Chinese clients in Brazil, they're not really worried about the seat or the applicable law. They're really pragmatic, and I agree that sometimes the arbitration agreement is a midnight clause in these contracts with Chinese investors. I think they really, and from here we have a different experience, because my experience with these clients is that there are many layers of decision making, different from a Western company where you have like 2 or 3 layers. In China, you have like 8 layers of decision. So when you start a negotiation process, it takes much longer for the decisions to come down. So it's really a more pragmatic approach and more business approach than a legal approach to this contract. So My interpretation of both decrees is that it's not a commercial bank. It's an institutional bank, public bank. Yeah. But also agencies such as in China, CDB, Sinosure, Exim Bank. So all these institutions may use this breach of the law.
Thank you. I think I've toyed too much with the indulgence of the organizers. I think we should wrap up the session, and thank you all for your time. And would you please join me in thanking our excellent speakers? Lead the way.